It follows that the interpretation of woman in the Scottish Government guidance on the 2018 Act is incorrect, and the challenge to that guidance succeeds. It also follows that the 2018 Act, correctly interpreted, is within the legislative competence of the Scottish Parliament. Finally, as I flagged up earlier, the correct interpretation of the EA as referring to biological sex does not cause disadvantage to trans people whether or not they possess a gender recognition certificate. Trans people have the rights which attach to the protected characteristic of gender reassignment. In addition, as we explain between paragraphs 248 and 263 of the judgment, they have protection against direct discrimination, harassment and indirect discrimination by association with members of the sex with which they identify. A trans woman can bring a claim alleging sex discrimination because she is perceived to be a woman or by her association with women. It is now well established that direct discrimination because of a protected characteristic encompasses not only cases where the complainant affected by discrimination has the protected characteristic in question, but also where the discriminator perceives that the claimant has the characteristic or in some way associates the complainant with the protected characteristic. A trans woman is similarly protected against harassment under Section 26 of the Equality Act. Further, the principle of discrimination by association remains part of our law, see Section 19A of the EA, and protects transgender people against indirect discrimination, regardless of whether they possess gender recognition certificates. A certified sex reading is not required to achieve any relevant purpose in relation to indirect discrimination. For these reasons, the court allows the appeal.
The court will now adjourn.